Good afternoon, ladies and gentlemen. I'm proud to be here, and I would like to thank the organizers, in particular Malati, for giving me the opportunity to speak here. I'm going to speak about a set of decisions from the Enlarged Board of Appeal of the European Patent Office called the broccoli and tomato cases. And that's a long-lasting story now. They are discussing these cases since more than 10 years. And one of the last twists in that story were amendments to Rule 28 GIPC. Let me briefly introduce the legal situation here. One of the basal regulations is Article 53b GIPC, which excludes plant and animal varieties. It's quite similar to the Indian situation. And as well, essentially, biological processes for the production of plants and animals, so in particular, breeding methods. Then we received a decision in the so-called Novartis case over 10 years back. And in that decision, it was specified that plant varieties per se are excluded from patentability. However, if the plant varieties are not individually claimed, then there is no exclusion. So even if a claim may embrace plant varieties. The transgenic plant inventions were generally considered allowable. So let's have a look at the tomato broccoli decision round one. The procedure started in 2007. The broccoli claims they relate to a method for the production of Brassica oleracea with an elevated level of glucosinolates. And there we have different steps, like a crossing step, a selecting step, another back-crossing step, and another selecting step. The tomato claims are somewhat different, but they comprise similar steps. So here we have a method for breeding tomato plants. And the tomatoes have a reduced fruit water content. We have crossing steps herein, collecting hybrid seeds, a growing step, another collecting seed steps, and finally a screening step for reduced fruit water. The question was, would these methods actually represent essentially biological processes and thus be excluded from patentability? And the Enlarged Board of Appeal decided that a non-microbiological process for the production of plants which contains or consists of steps of sexually crossing the whole genome of plants and of subsequently selecting plants is excluded. So that was the definition of the Enlarged Board of Appeal. The next section is probably even more important. Such a process would not escape the exclusion if it contains a step of a technical nature which serves to enable or assist the performance. So adding some additional technical step doesn't really solve the problem here. Unfortunately, there was no ruling on the question of product by process claims. So this was merely linked to the methods themselves. So the next logical step was the question about the product by process claims. And well, what happened? Patentee actually cancelled all the method claims, and they focused on the product claims. And then the story went on. So the same cases went up to the Enlarged Board of Appeal again a few years later, and they had to decide on the product by process claims. So one of the questions was, can the exclusion of the processes, can this exclusion actually have a negative effect on the allowability of a product claim? Or more specifically, is a product by process claim, is it and essentially, is a product by process claim directed to plants or plant material other than a plant variety allowable if its process features define an essentially biological process? So that was the exact question. The answer to that was delivered after some very tense discussions and a very intensive research on the legal sources, in particular the Biotech Directive of the European Union. And the Enlarged Board of Appeal finally came to the conclusion that the product by process claims can be allowed. So that was the official answer here. The exclusion of essentially biological processes for the production of plants does not have a negative effect on the allowability of a product claim. Then, as a next twist to that interesting story, the European Parliament asked the European Commission about comments on the relevance of the Biopatent Directive I've mentioned before. So the Biopatent Directive is the legal framework for the European Patent Convention in terms of biological inventions as well. And the European Commission delivered a notice, and they interpreted the exclusion from patentability of products obtained by essentially biological processes. Well, interestingly, the European Commission came to a different conclusion than the Enlarged Board of Appeal of the EPO, and they said it was the legislator's intention when adopting that Biopatent Directive to exclude from patentability products which are obtained by means of essentially biological processes. In other words, product by process claims would not be allowable. Well, as you see, this interpretation is at odds with the Enlarged Board of Appeal's interpretation. However, we have some national patent laws which include such an exclusion, in particular in Germany, but also in the Netherlands and in France. Well, the European Commission is believed to have provided that interpretation in order to avoid amendments to the directive, and it's probably politically motivated. Well, the next chapter in that story is that the EPO then took that notice and used it as motivation for amending the EPC regulations. So in particular, Rule 27 and 28, and that happened in 2017. So that new section to Rule 28, it excluded now from patentability plants or animals exclusively obtained by means of an essentially biological process. That would apply to applications and patents, so it's a retroactive regulation. But as you can imagine, we have some unclear notions in that rule. So what actually does exclusively obtained mean? In order to clarify that, the EPO has afterwards amended its guidelines, and that happened in November last year. And it tries to explain a bit what the terminology actually means. So exclusively obtained by means of an essentially biological process is supposed to mean where no direct technical intervention in the genome of the plants or animals takes place, as the relevant parental plants or animals are merely crossed and the desired offspring is selected for. Then it goes on, the term exclusively is used to mean that a plant or animal originating from a technical process, so technical process is important here, or characterized by a technical intervention in the genome is not covered by the exclusion. And then they provide some specific examples like targeted mutation, and they mention CRISPR-Cas here, or random mutagenesis like the UV-induced mutation, and these are technical processes according to the EPO. If you look at the offspring, and if the mutation or the transgene is present, then the offspring is not produced exclusively and therefore would be patentable. Well, a specific problem was identified in case you could have genetic modifications which are possibly introduced via genetic engineering or alternatively via classic breeding. Let's assume that there is a single nucleotide exchange in the genome, but that could be the result of a technical intervention, so directed mutagenesis, or an essentially biological process, so it could be a natural allele. In such a situation, you need a disclaimer now. A disclaimer is also required in all cases, even if the description would only mention a technical method of production and would be silent on the essentially biological processes. Well, let's have a look at examples of such disclaimers. I will mention only two. So a cultivated pepper plant expressing a mutated AHAS enzyme with the proviso that the plant is not exclusively obtained by means of an essentially biological process, or a tomato carrying a mutation in gene X with extended shelf life in comparison to a wild-type plant with the proviso that the plant is not exclusively obtained. Well, as you can imagine, there were several concerns about the disclaimer approach. One of the problems is the terminology. So what exactly is a transgenic plant in comparison to a genetically modified plant? We have no suitable definition here. Then another problem was the comparison of the random mutagenesis with the targeted mutagenesis. Both were considered as technical processes. However, a random mutagenesis is not a pure technical process, since its results are mostly not reproducible. Then another problem is, what is the meaning of the disclaimer if it comes to infringement? And I think the most important question is, how can a party actually prove that the material falls or falls not under the claim? So what we see here is that absolute product protection is no longer possible. Well, interestingly, this discussion, which started in November, ended quite soon and might, at the moment at least, be superfluous, because we have now a very recent development which concerns the conflict between the Article 53B and that Rule 28.2 EPC, as we've seen before. So we had the interpretation of that Article 53B by the Enlarged Board of Appeal in Tomato 2, and that was in contradiction to, or is in contradiction to, Rule 28.2 EPC. Interestingly, the amendments were decided by the Administrative Council. They can amend the rules of the EPC, the implementing regulations. The articles, or changes to the articles, that's only possible via a diplomatic conference. That's a much higher level. And if there is a conflict between the provisions of the convention, so the articles, and the rules, then the provisions of the convention, meaning the articles, shall prevail. And that is exactly what happened in that case. So we had this case T1063 from 2018, and there the Board of Appeal had to deal with a case where the examining division was rejecting a patent application due to that new Rule 28.2. All proceedings took place in December, and the board decided, well, the amended rules are in conflict with the article, and therefore that new rule is void. So it is not working and shall not be used by the examining divisions. So what are the consequences? The examining divisions will no longer refuse patent applications under Rule 28.2. And now everything depends on the legislator. So what is assumed is that there might be an initiative to amend Article 53B, but in order to do that, you need a diplomatic conference, which is complicated to organize. And then another aspect to that story is that the modification of the EPC, of the law itself, would have no retroactive effect. So what was possible before, that you could apply the new rule to applications and patents alike, would no longer be possible, because granted patents would be excluded here. Another option, less likely, is an amendment to the Biotech Directive, as I've mentioned before. But the amendments are potentially risky, because if the Biotech Directive is open, or the discussion on amendments to it is opened again, then several other sections might be amended as well, and that is considered detrimental for the biotech sector in Europe. So no one really wants to do that. And you would actually end up with a legal uncertainty with corresponding economical consequences. So I believe that this is not going to happen, but an amendment to Article 53B is at least possible. So we expect new developments in this story in the near future.